Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. In a just released document in Idaho versus Koberger dated March 24th, 2025, the defense, in its reply to the state's response to defendant's motion in Limine number 12, this is regarding make and model of suspect vehicle 1, the defense several times drives home a very important point, which is that the jury and no one else, not the state, not the judge, not the defense, or anyone else in the world, has the legal authority to make findings of fact, to make determinations, for example, if any piece of evidence that comes before the jury is credible or not credible. In this reply, this is the final step in the briefings, where the defense is attempting to persuade Judge Hippler to grant this motion. They point out on page 2, the Idaho Rules of Evidence states that relevant evidence is admissible and defines what relevant evidence is. It says here, relevant evidence is that which has any tendency to make a fact more or less probable than it would without that piece of evidence, ladies and gentlemen. Then the defense says the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, or misleading the jury. So basically what this is, if you can think of a scale in your mind, and if the evidence and whatever probative value it is outweighed by these dangers pointed out here, unfair prejudice, confusing the issues, or misleading the jury, then the proper determination is that it should be excluded. And this is what defense is saying is happening here. Here, according to the defense, Mr. Koberger's motion sought to prevent the state from saying that the vehicle depicted on the 1112 King camera was a Hyundai Elantra, and that the vehicle was the same vehicle identified as an Elantra on the 1125 Ridge camera. This issue, the defense says, is in the province of the jury. Only the jury, in other words, can determine if the car that was depicted on the 1112 camera was the same vehicle depicted on the 1125 camera. That, according to the defense, is only a conclusion that the jury is authorized under law to make. Then, the state points out that there is no continuous video stream to observe a path of travel. As the state points out, they cannot show a vehicle at 1112 continuously moving to the location of the 1125 camera. Because they are two separate videos separated by distance, an opportunity for other places to drive or park, an opportunity for other vehicles to appear on camera, it is a question for the jury. In other words, is this the same vehicle that's being picked up on two different cameras separated by distance and time, or is it not? Only the jury can determine that. That's what the defense is saying here. The state's label and claim that the vehicle on the various videos is the same is a fact to be determined by the jury, is how this concludes. This is dated the 24th day of March, 2025, and Taylor on behalf of defense. So the court has to make a decision here if under the law, under the rules of evidence that have been cited here, if it is indeed the province of the jury to make these conclusions of fact or not. So we await the hearings on the in limine motions coming up on the 9th and 10th of April, and then thereafter we anticipate that the court will be making written rulings in the form of orders that could change the direction of the case based on how the court rules as the trier of the law. This is Kathy. Thank you for joining us here today.